broker introduces you to Microsoft and wants to buy the name, and he's only got a 30-day contract,
Yeah.
and you let that contract expire on day 31, you say, hello, Microsoft.
Yeah.
It's so...
Serious about online trading? Secure your funds, keep your merchandise safe, and use a company that keeps both the buyer and seller protected the whole way through. That's escrow.com. Payments you can trust.
Welcome everybody, I'm Angela St. Julien, founder and publisher of Brand.bar's Happy Hour Chats, and I'm sitting here with Zac from dnattorney.com. Hey, Zac.
Hi, Angela. Thanks so much for having me. So happy to be here in Florida at the Dominion Conference.
Yeah, it's fun.
And thanks for taking time to speak with me today.
No, thank you for taking the time. I know you've been busy. You've had some sessions and stop and meetings.
That's right. So this past week, the Internet Commerce Association asked me to be on the board of directors, and so I'm very happy to volunteer my time to that great organization, which advances the rights of domain name investors. That's their primary objective, and I know you're involved with it.
Yes, I am
I'm
now.
very happy to have you as a member as well.
I'm excited to be on board now. So, by the way, did you get a pen?
I did.
Oh, you're supposed to wear your pen on your lanyard. You're supposed to
I
wear
knew
your
I
pen.
forgot something this morning.
I'm going to get you another pen. So, while we're hanging out, let's talk a little bit. You know that, Happy Hour Chats are really geared towards newer domain investors coming into the space. And when I'm on forums and, even reading articles and reading comments, I see a lot of questions from, newer domainers about all things legal aspects of domaining.
Yes.
Trademarks, contracts. What's the most, common question you receive?
So, domain investing is such a great business because you could pay $10 and get a domain name that you could flip for a lot more money. At least that's what a lot of people aspire to do, right? Mm-hmm. And that's the legitimate investment model of the domain industry. But other people are attracted to the other side of it, which is to register a domain name that corresponds to a famous company's trademark, for example. And they are sometimes under the misapprehension or misunderstanding that that's okay.
Yeah.
And it's not. So the general rule is that you can register Apple, for example, because you want to sell apples, but you can't register Apple to sell computer parts or to sell back to the Apple company. So it's all a matter of whether you register a domain name in good faith. So if you picked a name because it's some company's trademark, that's a no-no.
Yeah.
And even if the registrar sold it to you for the registration fee, that doesn't mean that it's
okay.
legal or okay to register, and so you could get in some trouble for that.
Right, because reasonably a registrar can't police that, right? So many people come to their site every day registering names.
That's right.
How could they know?
Yeah, exactly. They don't police it at all.
Yeah.
And, it's a real poor analogy or example, but it's like a knife store, right?
Yeah.
You could buy a knife for dinner, you could buy a knife for some other purpose,
Yeah,
and the knife store isn't there to police it.
Exactly,
Yeah.
that's true.
Yeah.
So, say an individual, well-meaning, good intentions, not actually deliberately registering one of those companies' marks, but they have, and they get an email or a call, what should they do?
Sure. Well, often just because you register a domain name because it happens to be a company's trademark doesn't mean you've necessarily done anything wrong, right? So, for example, if I registered, napkin.com, there could be a company in Europe or in China that has a trademark for napkin.com for a brand of headphones. And if I didn't register it for that reason, it's just a coincidence that they happen to have a trademark.
Okay.
That doesn't give them a monopoly over this word for everything. Napkin has a meaning that I'm entitled to use the domain name for example. So just because you get a cease and desist letter or a call from an attorney or company saying that you've got trademark rights doesn't necessarily mean that they're correct or that they have the right to your domain name. In fact, a large part of my law practice is explaining to those lawyers and companies that have trademarks that they've got no rights to my clients' domain names despite their trademark.
You know, and talking trademark, I know I said I was really going to be speaking to the newer domain investors coming in, but this made me think too of a friend of mine who's been doing a certain type of service, I'd say baking,
Yes.
for like 10 years, using a name for herself locally while baking these goods. And she finally decided, you know what, I'm going to take this skill that I have, you know, this thing I've been doing all these years, and I'm going to make it into a real business. And she's ready to, you know, get her license, like say in the state of Texas, register her business name, get her domain name, get her website up. And she finds that someone else already has the same name, even if they're not using the domain name. But they also have a trademark. Could she still buy the common version of that name to use for her business, even if they're doing the same service, because she's been doing it for 10 years? Or does she have to stay away from it, even, you know, having had prior use, because there's a trademark?
Sure. So trademarks are by jurisdiction, by country. So if you have a trademark in the United States, it's valid for that country. And what it does is it gives you monopoly over that brand within the United States for some very specific goods and services that are listed in your trademark registration. So if someone had a baking business called ABC, for example, and she wanted to register a trademark, the first thing she would do is have a search done, or search herself to see if anyone has ABC for baking or for a restaurant, because that might be close. And if someone did, that could give her a problem, because even though she's been using it, they have the registered trademark, and that should give them a monopoly.
So like a preference.
Yes, and they could in fact try to stop her from using her
it
brand.
as well.
But there are exceptions to that. For example, it might be that she started using her brand before they even got their trademark. And if not a lot of time has passed, she might be able to cancel their trademark and get one for herself.
How does one prove that they've been using the brand before the person who's filed their trademark?
Right. Well, in most trademark registrations, the trademark owner has to specify the date that they started using it. So they might say April 1st, 2008. And if you're able to show that you've used your trademark through business cards, letterheads, advertising, magazines before that, there might be an argument that you're the person that's entitled to that trademark rather than them. But this is a complex area of trademark law, and it's most of the time it's probably not worth getting into a big trademark fight.
You might as well find another name,
That's right, a lot easier.
And with things like brandables for something like that, there could be so many, options out there.
That's right.
So now let's kind of make a little bit of a pivot, and let's talk contracts.
Yes.
Because that's something else I've seen, when I'm, chatting in forums and things. I've seen questions about that. Where can I find, like a standard agreement for, between two people to sell a name, or where can I find an agreement for leasing a domain?
Right.
What kind of contract, all those kinds of things. What have you experienced as far as questions about contracts?
Yeah, so everyone has heard that, get it in writing. It's always good to have contracts, and that's obviously true. It's always good to have a contract because it specifies what each party's obligations are. However, in the domain name industry, especially for beginners, sometimes it's not always practical to have a contract for a few reasons. One is that contracts can slow down transactions. So if you're selling a domain name to someone for $500 and you say, listen, I'm going to have to send you a contract, you send them a 10-pager, they'll be like, you know what, that means I have to hire a lawyer, I got to read it, and all this is not worth it, right?
$500,
that's another name, right? But now if you're talking about a $50,000 transaction, the other party's probably expecting a contract and probably wants one themselves. So it's a matter of judging whether a contract is appropriate for the particular circumstance and whether the cost is something that makes sense for a particular transaction. So and often using different escrow services like escrow.com or some of the other competitors, or even ones that a system that Uniregistry has for transferring domain names. Often contracts for purchase and sale of domain names are avoidable by using these electronic systems to some extent. Of course, I can't recommend that as a lawyer. I say always use a contract, but there are ways of avoiding it.
And this might sound like a really simple question, but I'm going to ask it because I'm sure others might be wondering, can an email be considered a contractual agreement?
Right. So the answer to that is yes, and I'll even take it one step further. A verbal agreement can be legally binding as well. So a contract really, in its essence, is two parties who are agreeing, each party agreeing to do something and exchanging something of value as a result. And that can be done verbally between me and you making an agreement, or it can be done by email, or it could be in a lengthy formal document. All three are binding. The difference between those, though, is just one of evidence. How do I prove that me and you have this conversation? Is the email specific enough that a judge would say this is a real contract?
Clear.
Is it clear enough? Yes.
So maybe newer investors who might not have a lot of capital to pay for, a good, quality contract from a lawyer, maybe they can possibly use email if they're kind of clear.
Absolutely. I mean, if they spell out who the parties are, their contact information, what each party is agreeing to do, the price involved, when the money is paid, those basic kinds of things that go into a contract, and they get the other person to say, yes, I agree, by return email, that would be fairly good evidence in a fairly good contract, and something that might make sense when you're starting out, rather than slow down your business or increase your expenses to hire a lawyer at that stage.
And then if it's something simple, like maybe a smaller type of transaction or a minor type of agreement, it might be good. Obviously, in the case of that $50,000 name we were talking about, they probably want to do the real contract,
that's right?
So, and I want to look at this because I wrote down notes. I wanted to make sure I asked about this. What kinds of contracts, would a domainer typically see that can be considered standard, and what kind of contracts is one where you would think, okay, I really need to have, or possibly have, a lawyer take a look at this first before I agree to it or sign it?
Sure. But the simplest kind of contract that I see is just a purchase and sale agreement for a domain name. In fact, I rarely even see those because most people don't use a contract for simple, lower value domain name transactions. One where I sometimes see that people can use some help is in domain name brokerage agreements. And I write domain name brokerage agreements for domain name brokers, and I also sometimes counsel people who own domain names that are thinking of hiring a domain name broker. And the key component of a domain name brokerage agreement that people should be paying attention to is the same as in real estate. It's this exclusivity period. So if you own a domain name and you're hiring a broker to help you sell it, and he or she is really enthusiastic about their ability to contact different people and try to market for you, that's great. But it doesn't always work, and so you need to give them a reasonable period of time to do their best.
That job.
Is it going to be 30 days, 60 days, 90 days? Is it going to be 10 days? And so that's what we need to pay attention to. And one of the more subtle aspects of those agreements, too, that people don't always catch or pay attention to, is that some agreements like this have a provision that if the broker introduced you to somebody during the agreement and you don't do a deal with them and the agreement expires after 60 days, for example, but then you do the deal with them down the road, you still have to pay the broker commission. And that can sometimes create a problem because you end up paying two commissions.
Right. Yeah. So how long does that last, or should that particular clause last?
Right. Well, holdover clause, it's called a holdover clause, generally. And it's really a matter of negotiating between the parties. There's no rule of thumb for it. But I guess the main consideration from the domain owner's perspective is that they need to be real if they're going to agree to holdover costs, which is fair to the broker sometimes, because if the broker introduces you to Microsoft and wants to buy the name and he's only got a 30-day contract, and you let that contract expire on day 31, you say, hello Microsoft, that's why the brokers have it. But from the domain owner's perspective, you want to make sure that the contract really is specific about, does it take just an introduction? Does it take a negotiation to have started? Does it take just sending an email out to Microsoft to trigger this?
Communication between, parties.
That's right.
Yeah, okay, so it might have a slight level of sophistication to it that can make it, maybe more lengthy or kind of short. Right. So, last question. I'm going to ask him one more question because we actually have to get back to sessions. I'm wondering if we, as domain investors, should consider buying standard contracts and using the same one, rinse and repeat. Can you do that?
Yeah, okay, so great question.
Make slight changes or...
So, there's Rocket Lawyer, there's Megadocs, there's companies that sell templates, so you could Google and find templates. And lawyers, even at the largest law firms on Wall Street or Fifth Avenue or wherever.
Or D&A Attorney.
D&A Attorney, sure. They use templates too. In fact, they have files just with different templates. And so getting a template is easy, right? The hard part about it is actually understanding what it says. So here's a really good example. If I just Googled and found a template, and it looks like a real legal document, it looks very professional, and it has that holdover clause in it, and I don't really know the implications of that, I could run into some trouble. Okay. And so that's where the skill of lawyering comes in, not providing a template, because that you can get yourself. It's the counseling and advice and the experience of knowing what clauses are appropriate and what should be taken out. Because there's no such thing as a standard form of contract that applies to every situation.
Thank you so much.
Oh, my pleasure.
You guys, if you want to know more about how you might be able to protect yourself, get contracts, trademark information, what else do you do? Over at D&A Attorney.
I cook dinner.
Get dinner. You'll be in Canada though.
Well, thank you so much for having me.
Go over to danattorney.com and check out the site. Get to know the services that Zac offers. I actually have used your services.
Absolutely.
And I appreciate that.
My pleasure.
So I appreciate it. Thanks for taking the time.
Thank you.
Let's get back to session, huh?
Let's do it.
Okay, thanks.